Hey, welcome back, faithful politics listeners and watchers. If you're watching on our YouTube channel, make sure you hit that subscribe button. It definitely helps us out quite a bit and allows us, more opportunity to provide great content to you. And this week with us, I should probably introduce myself. If you've never seen this show before, sometimes the start of these episodes can get kind of wild because we forget that like to do the things we always do. So I'm your political host, Will Wright. I'm joined by your faithful host, Pastor Josh Burtram. How's it going, Josh?
Doing well. I'm so glad I never forget. I never ramble on in the beginning.
It is good. It is good.
I'm so bad at it, dude.
Yeah. And returning to our program today is Eric Berger. We love talking to Eric Berger. He's been on the show a couple times. He is a distinguished constitutional scholar and professor of law, specializing in administrative law, constitutional interpretation, and the separation of powers. And I should point out that he is the first of what I expect to be many constitutional scholars that we are going to be speaking to in 2025. And with the onset of the new administration, I think we'll get lots of opportunity to do that. So welcome back to the show, Eric.
Thanks very much for having me back. It's always a delight to talk to you both.
Yeah, so the last time we spoke, gosh, I can't remember. It was a couple years ago. You've been a bit of a world traveler, kind of gone all over the place, and now you're starting a new semester. New semester, or is it like in the middle of the semester?
New semester started last week.
Yeah, I am kind of curious. This isn't one of my interview questions, but I am curious. Like as a constitutional professor, do issues that occur like in the news, like are those good things for your curriculum, or are they like terrible things for like when you're planning
Well, that's
your
a good question. I mean, I always try to work it in and explain how what we're studying is relevant to those issues. And if it's a big case, like last year, for instance, the Trump immunity case, obviously a huge case, had not been decided yet during the semester, but was argued during the semester. So we took at least a whole class, probably a class and a half, to discuss that case. And I tried to do it at a time where we were reading other relevant cases. So, so that is fun. And I think it's rewarding for the students because it helps show how what they're learning, they might be reading a case from 30, 50, 100 years ago, but it helps show how that's relevant to things that are in the news today. It can be a little disruptive because, you set your syllabus up and then, there usually, though, if there's going to be a big case in the pipeline by the start of semester. But, there is a lot of variation from year to year. And when I go back, if I look at what I've taught or my syllabi from 5, 10 years ago, it's amazing how much new stuff there is. So certainly it's not a time where con law professors have been bored in the last decade or so.
Yeah, I'd imagine like this scenario where you're assigning homework, like I want you to write an APA formatted 25-page paper about why presidents are not immune. And then like the SCOTUS decision comes down, you're like, okay, never mind.
Oh wait, take all that back.
Yeah,
I want you to write why you're afraid that the president is no longer immune.
Right. Yeah. I have learned. When students ask me to give predictions, I've learned to say that I usually get it wrong, and. Or at least to say it can be hard to predict. The case book I teach out of in this section about immunity had a sentence or something in the last edition that basically read, although the Supreme Court has never explicitly decided whether the president would have immunity in a criminal case, like the common wisdom is that he would not. So I imagine the next edition of the case book will read differently in that section.
It's the
darn common wisdom.
Yeah, big publishers are out there trying to make money, so they're affecting politics. I mean, it's all part of the globalist plan to take over, colleges. But
don't forget the deep state. Don't forget the deep state.
But anyways, yeah. So
That's what we'll
I wanted.
talk about today, I gather.
Yeah, yeah. We're just going to focus just on this one little narrow thing that nobody really cares about. But one thing I do care about is the administrative state, and that's one of the things that we asked for you to come on to kind of talk to us about, kind of help us understand, what is the administrative state, why we should care about it, how we think it could change in this next administration. So maybe we just start from there and define for us like what is the administrative state.
Sure. So, I mean, the administrative state is basically like the vast federal bureaucracy. It is any part of the government, that is not Congress and is not the president of the White House and is not the courts, is an administrative agency. Most of those agencies are housed within the executive branch of government, and these are the institutions that get the business of our government actually done. They're the ones that enforce the laws that Congress writes. They implement the laws that Congress writes. They are the parts of government that try to protect us from planes flying into each other at crowded airports and protect us from contaminated foodstuffs and dangerous medicines and dirty water and dirty air and all the rest of it. So it is an enormous part of our government. Administrative agencies are created by Congress. Congress passes laws that create administrative agencies, and then depends on the kind of agency, but for a lot of agencies, the president will appoint the head of the agency and can remove the head of the agency. So they're, to some extent, often largely accountable to the president, but the theory, at least, is that they also have expertise over their area or over their special areas so that they can help implement and craft rules in such a way that are more free from politics and more, in keeping with the expertise they've amassed over time.
Got it. So folks that kind of are part of the administrative state or create the environment in which the administrative state exists, that probably doesn't really make sense. But in essence, like what I'm getting at is are the folks that you're talking about what we would consider like government employees or a Schedule F type of employees or anything like that?
Right. So, I mean, they're basically two. This is obviously painting with a broad brush, but they're basically two categories of employees at administrative agencies. One would be political appointees who are the heads of the agencies, the leadership of the agencies. And typically, and I'll talk primarily about what's called executive agencies, which are those agencies that are more directly answerable to the president. But typically for executive agencies, the president of the United States appoints the head of those agencies, the leadership of the agencies, with advice and consent of the Senate. And that's obviously really relevant to what's going on in the news right now because we've already begun Senate confirmation hearings for many President-elect Trump's nominees to head many of his agencies. So the heads of the agencies are appointed by the president with advice and consent of the Senate. And they can also be removed by the president, which means that if the president doesn't like the direction the agency's going, if the president thinks the agency isn't pursuing the president's agenda quickly enough, the president can remove the head of that agency and put in someone else to advance the president's agenda more. So that's the first category of agency employees. The second category is civil servants, and that's where Schedule F that you allude to comes in. Civil servants are not political appointees and historically have been legally protected against political removal. They could be removed for cause, if they don't show up for work or if they steal money, something egregious. But legally, historically, in a lot of agencies at least, they can't be removed over a policy disagreement or something like that. And the idea with the civil service is that these people have a sort of deep expertise in the area they're working in. whether that's public health or the environment or workplace safety or federal aviation, whatever it is. And they are exercising that expertise to try to serve the American public. Now, you mentioned Schedule F. Late in President Trump's first term, he proposed Schedule F, which would have reclassified some civil servants to try to give the president more direct control over those civil servants, so that he could influence what was going on more. Josh alluded to the deep state earlier when we were chatting, and that was the language that President Trump used, the sort of vast bureaucracy. I think his thinking was that it was not responsive enough to his goals and his whims. So he proposed that Schedule F that would have reclassified a number of civil servants as employees that the president could then remove or exercise more control over. He then lost the 2020 election, and President Biden came to office and quickly rescinded that move by Trump. So we never got to see exactly how Schedule F would have played out, exactly how many civil servants it would have affected, exactly how it had affected them. There very likely would have been litigation challenging the legality of this, since, again, the longstanding assumption has been that those civil servants, unlike the political appointees of agencies, are not as politically answerable, and they're more insulated from political meddling. But now that Trump has been reelected and is returning to the White House, we very well could see, something like that, and we'll just have to see how it plays out in the courts.
So this is so interesting to me because Trump is so funny is not the word that I'm looking for, but no, the way that he uses words are very intentional, right? So this administrative state and then these civil services, or servants rather, he calls, this deep state, and essentially like tags them with this idea and this concept about this deep state, implying something negative, this negative connotation, when it's kind of just like, hey, people that have been there for a while are experts in what they've, in their particular area, whatever domain that they're active in. And it's just, it's so interesting how he takes these words and makes them, kind of puts different meaning to them. And, we've had several people on our show, Eric, that have talked about their deep, deep concern that Trump was essentially going to gut the government, the Department of Government Efficiency, handing it over to Ramaswamy and
Vivek Ramaswamy and Elon Musk.
Swami. I said Swami.
I was going to let you like that.
Oh, dude, thank you for the correction. But you have this like department that's going to come out, and they're going to, who knows what they're going to be able to do, which I'm super curious on, like what you think about this whole department and how like a president can really do this. So I guess the question I'm getting at, and you're beginning to allude to it, like we're going to see how it goes in the courts, but how likely is it that President Trump, like what has to happen, I guess, for President Trump to come in and start cleaning house? Like, and you had mentioned like they're not doing whatever his goals or whims are. I didn't, in my mind, like a whim, we don't want to just have things done because of a president's whim, right? Necessarily. And so I would love, like, what does it actually need? What actually needs to happen, or would have to happen for him to be able to like establish this Doge and then really start gutting like the government?
Right. So, I mean, it's a great question, I guess. And, I don't have like a neat and succinct answer, but I'll throw out some ideas that I, hopefully are somewhat responsive. So I guess one maybe pedantic point, but I think it's an important point to make is, DOGE, what President-elect Trump calls the Department of Government Efficiency, it's not actually a department because a department has to be created by Congress, and Congress hasn't created DOGE. So what it really is a sort of a think tank or an advisory body that exists entirely outside the government, but is presumably going to give President Trump and other people within the government advice about how to make government more efficient. I suppose it is theoretically possible that Congress could create an actual Department of Governmental Efficiency, and that Trump, once president, could appoint Musk and Ramaswamy to head that. I think that's very unlikely because you need to get it through both houses of Congress. And even though the Republicans control both houses of Congress, they would have to get over the filibuster in the Senate, and they don't have anywhere close to the votes to do that. And B, their margin in the House is so narrow that, they need virtually every single Republican to sign on. And we've already seen some sort of splits in the Republican ranks. But that said, I think you're right that there is a concerted movement among, not only Trump, but many other conservatives to sort of rethink the administrative state. I guess I'll make, a couple of points about that, maybe that are somewhat in tension with each other. One is, I do think that some of the critique of the administrative state is fair, at least from a broad level, insofar as there is some inefficiency. There are rules that impose greater costs on businesses than the benefits that come from the resulting regulations. There are individuals who get harmed by administrative actions. And agencies also do make mistakes, which I think is something the Republican Party has really latched onto. At the same time, administrative agencies play a crucial role in protecting the American public from all kinds of dangers. And, we used to live in a country where rivers would catch on fire, where, children would die from drinking contaminated milk, where industrial workers would be killed or maimed in very large numbers every year. In other words, we lived in a country where ordinary people going about their daily lives faced tremendous risk to their lives and to their health on a daily basis. And probably more than anything else, administrative agencies have played a huge role in protecting the American public from those dangers. So, there's also the risk of, doing away with administrative regulations too much, because it would remove a lot of those protections, and we'd really be in sort of a wild west. To get to your question about, well, can the government actually do this? The answer, I think, depends on what it is the government is actually going to try to do. One thing we've heard President-elect Trump talk about is getting rid of the Department of Education. Well, that would be awfully hard to do, because that would require an act of Congress. And as I said a moment ago, it's pretty unlikely you would get Congress to march in step to do that. At the very least, I think a Democratic filibuster in the Senate would kill that. The Schedule F situation, though, is much more a real possibility. But again, it remains untested in the courts, and we haven't seen exactly what that would look like. So we don't yet know exactly how many civil servants it would apply to, exactly how much control the president and his allies would try to gain over those employees, and whether or not the courts would reject those efforts to the extent that many of those employees, were operating under contracts where they thought their employment was where they could only be fired for cause, and so this would be changing the terms of their employment in a significant way. That's sort of a long-winded answer. Maybe a little bit later in the program we can talk more about the court's role in all this, because the Supreme Court in particular, has played a significant role in cutting back on administrative authority, and exactly how what the court is doing interacts what the Trump administration will do, I think is an interesting and open question. But I mean, does that sort of answer your question, Josh?
Yes, definitely. Yeah.
You forgot, Josh. Podcasting is an audio medium, so like when you do a thumbs up,
I'm just such a YouTuber. Well, I just can't help it anymore. I'm just such a YouTuber.
So yeah, I do want to talk about the court. So how much bearing does the change in like the Chevron doctrine play into the administrative state? And if it does, maybe you can just kind of unpack, what that case was and explain what the Chevron doctrine is.
Yeah. So no, I guess my own view is that the overturning of the Chevron doctrine, is itself maybe a relatively modest change, but in conjunction with several other important administrative law decisions of this Supreme Court, signals a more dramatic change, and in particular, a change where we see the federal courts being far more aggressive in second guessing what it is administrative agencies are doing, and making it a lot harder for agencies to go about their work without federal courts interfering. I'll talk about the Chevron because I think that's the most prominent of those changes, but then I'll briefly put it in context with some of these other decisions. So as you alluded to, in a decision the Supreme Court handed down this past summer called Wright, the Supreme Court overturned the Chevron doctrine. Chevron was a decision from the mid-1980s where the court said that administrative agency interpretations of ambiguous statutes should be deferred to by courts. So for non-lawyers out there, so what does that mean? So we've already had a conversation about the administrative state and administrative agencies. Whenever an administrative agency acts, basically whenever an agency does almost anything, it is acting pursuant to a grant of power from Congress. So in other words, Congress passes a statute, the statute creates the agency, and it gives the agency marching orders saying, we want you to take care of A, B, and C, and here are the parameters on how we'd like you to do your job. And Congress obviously can pass additional statutes through the years to amend the scope of the agency's power, to take some power away from the agency or give the agency more power. But basically everything the agency does is via Congress. Congress is writing statutes that give the agencies instructions. So when agencies act, a question that invariably arises is the agency allowed to do what it did? In other words, is the agency properly exercising the authority Congress gave the agency? And oftentimes you'll have regulated entities who don't like some regulation that applies to them, and they bring litigation. And one of the arguments is the agency can't even do what it's trying to do or what it did because it's going beyond the power Congress delegated to the agency. Sometimes it's entirely clear from looking at the statute what the agency can do and not. You read the statute and you can say, yeah, of course the agency can do that. Or you read the statute and say, well, that's pretty clearly outside the agency's wheelhouse. Agency can't do that. But as you might expect, there are lots and lots of cases where it's just not clear, where Congress has written an ambiguous statute. I think Congress sometimes does that deliberately, and Congress sometimes does that because it's very hard to draft statutes. And it's particularly hard to draft statutes to give agencies authority over an area where you know there are going to be future problems in that area, but you don't know what that problem exactly is going to look like. So the question arises then when an agency is interpreting an ambiguous statute and assuming authority to do something, should a court then accept the agency interpretation? And in Chevron, the court said yes. If the statute is clear, then the agency has to follow the statute, and the agency does not get any deference. So if the statute is clear, the agency must follow it. But if the statute is not clear, if the statute is ambiguous, then a court should defer to a reasonable agency interpretation of the statute. Justice Stevens, who wrote the decision in Chevron, one of the things he is reported to have said while mulling the case over is, well, I'm so confused, I go with the agency. And I think that's actually important to keep in mind, because a lot of these areas of law are highly technical. They're pretty difficult. Even very smart federal judges who are not experts in those particular areas of law can find them difficult and confusing. They often involve difficult judgment calls. So the court's idea was we defer to the agency where the statute is ambiguous. In the Loper-Bright decision that the court just handed down this past summer, the court explicitly overturned Chevron and said, no, we don't defer to agencies. It is the role of the courts to interpret statutes, not the role of agencies. So courts should not defer to administrative agency interpretations of statutes, even where the statute is ambiguous. So on its face, I think that looks like a pretty big deal. The reason I said that it's maybe, well, there are a few reasons I said where maybe it's not quite as big a deal as it seems. One reason is because the court hadn't been following Chevron for about a decade anyway. So to that extent, Loper-Bright just made formal what had been informal anyway. I still think it matters for the lower courts. The lower courts have been applying Chevron, and now they can't after Loper-Bright. But that's one way in which it maybe isn't as huge a deal as it was made out to be. The other reason, though, is there was a couple of really interesting paragraphs in the opinion where Chief Justice Roberts, writing for the majority, said, so courts should not defer to agency interpretations of statutes. But where Congress has delegated authority to the agency to make a judgment call, well, then that means that the statute, as properly interpreted, gives the power to the agency to figure out how to do this thing, and then courts must accept the agency's judgment. So, so in other words, the court still accepted the notion that Congress can delegate to agencies the authority to make judgment calls. I think what it took away was the ability to make those judgment calls where the statute is unclear. So in other words, where Congress has explicitly given to the agency the power to figure it out, the court is still going to defer to the agency. But where it's unclear what Congress is doing, then the agency is not going to get deference from the court. I guess maybe I'll stop there, but I'll just reiterate the point I made earlier, that I do think it's important to see the Loper-Bright decision as part of a larger set of cases in which the Roberts Court in the last few years, especially in this last term, really cut back on the power of the administrative state. And I can talk about, maybe that's too much inside baseball, but I can talk about those cases a little bit if that would be helpful.
Yeah, I think it totally would be helpful. I guess I'm just having a hard time wrapping my head around, so Congress delegates some authority to the agency in situations of ambiguity. Courts will defer to the agency also, but how is that line drawn? And then who draws it?
I mean, so that's an excellent point. And obviously there's always going to be questions about how ambiguous is ambiguous enough to trigger Chevron deference. That was one of the points Chief Justice Roberts made in his majority opinion overruling Chevron, which is there are all kinds of difficult questions about how to apply Chevron, when it applies, when a statute is ambiguous enough. So I think that is true. Those are difficult lines to draw, and invariably courts would have to draw those lines. I guess one point I would make is that the law always involves difficult lines like that. And even if the court is interpreting the statute for itself and not deferring to the agency, which is what the Supreme Court in Loper-Bright requires, there's still going to be really difficult judgment calls about, does the statute mean A or does the statute mean B? One of the classes I teach at my law school is statutory interpretation, and we come across a lot of statutes that Congress wrote that for one reason or another, or multiple reasons, are not clear at all. So, I think that's always going to be part of courts' role, is making judgment calls about what ambiguous laws mean.
So what can, I mean, I'm sensing a connection here, but I'm also, my head is feeling a little muddy with between the Chevron doctrine and like the major questions doctrine. Like it feels like they're connected, but I don't exactly know how. And I'm assuming they're not the same thing. So what is the major questions doctrine having to do? Maybe you can explain that and explain that significance, and especially in this context of Chevron and what we're talking about, and maybe even agency, the fear of agency overreach, things like that.
Absolutely. That's a great question. I don't know if you can hear my dog, but my dog has opinion from this too.
That's fine.
We're dog lovers here, so it's all good.
That's a great question. And you're exactly right that the major questions doctrine is another important administrative law development of the Roberts Court. And it's also related to the Chevron doctrine insofar as it involves how courts review what agencies do and how agencies interpret statutes. So the major questions doctrine is, I think depending on your point of view, either a brand new innovation of the Roberts Court or a significant extension of an earlier doctrine by the Roberts Court, is a doctrine that essentially says, we, the court, are not going to let an agency do something major, something of great political and economic significance, unless Congress has specifically delegated the authority to the agency to do that thing. And the court's reasoning is it's Congress's job to make the law, and therefore when agencies step in and make major policies, agencies are doing the work that Congress should be doing. So look, my dog's really going nuts, sorry. So let me give an example that maybe helps. So the Clean Air Act empowers the Environmental Protection Agency to, do various things to help protect clean air. Pursuant to its authority under the Clean Air Act, the Obama administration adopted a Clean Power Plan, and part of the effect of that plan would have been to incent more clean power. In other words, to push power companies to move away from dirty power like coal to cleaner power like wind and solar. And sort of as a side note, for various reasons, the Obama policy actually never went into effect and never was going to go into effect. So a lot of people thought, well, this case is moot and the Supreme Court shouldn't decide it. The Supreme Court decided it anyway. And what the Supreme Court said was that EPA had overstepped its authority because this is a major question. So in other words, even though Congress delegated to EPA pretty broad authority over clean air, this issue of how our power is produced, whether it's produced by gas and coal or by wind and solar, that's a major question, and it's of enough economic and political significance that it should be decided by Congress, not by the agency. So we're not going to let the agency do this. Unless Congress has very specifically delegated authority to Congress to do this. But that's usually not how delegations work. Usually Congress passes pretty broad delegations, go take care of clean air, go take care of workplace safety or whatever it is, and lets the agency work out the details. So the reason this is related to Chevron is, I guess the reason why it's related to Wright, which overruled Chevron, is this is another example of the court stepping in and telling an agency, no, you can't do what you did. The way it's a little bit different from Loper Bright is it only applies in a major case. But of course, to get back to Will's earlier point, the court hasn't been, very clear yet about what constitutes a major case. How do we know a case is important of economic and political significance enough to trigger the major questions doctrine? That we're not sure yet. But I think the takeaway is both Loper Bright and the major questions doctrine give courts, and especially the Supreme Court, a lot more ammunition to invalidate agency policies they don't like. So it empowers the judiciary to second guess agencies.
That's really good. You must be a pretty fantastic professor. I haven't checked your rating on the Rate My Professor website. I remember we had a professor on. We were talking about classified documents, stuff like that. And I told him, I said, "Hey, your students have rated you a 5," and he's just like, "What?" Like no clue that the Rate My Professor was a thing, And I was like, I don't regularly check, what people's ratings are before I ask them to come on, but I can tell. Well, like
you're very kind. I'm not sure my students would all agree with you, but you're very kind.
He also has two great
grades were just released a couple of days ago, so I'm pretty sure someone would not agree with you. But
You have 2 or 3 on the great courses. I've been listening to your latest one,
thanks.
by the way.
Oh, I appreciate that.
I love it, man. Anyway, go ahead, Will.
Yeah, I definitely want you to go back and tell us more about sort of like how the other things outside of Chevron getting destroyed is affecting the administrative state. So bookmark that just for a second. But like, I just want to make sure I kind of understand the major questions doctrine, kind of in more current terms. So like the TikTok ban, I've listened to a lot of different sort of takes on it. I keep hearing that like the major question doctrine could have been applied, or I think one of the episodes or one of the thoughts on it was like an intermediate doctrine or something like that. Like, is the major question doctrine, like as you described it, like something similar to the TikTok case? Like they'd have to apply it to that?
So I have queued oral argument for that case on my phone, but I have not listened to it yet. So
okay.
I haven't done a deep dive into that case, but I believe from sort of glancing at it closely that at least part of the TikTok case was a First Amendment challenge to the, I guess it's not exactly a ban, but the requirement that TikTok, be transferred away from a Chinese company. So the idea would be that because TikTok is a social media platform that engages in speech, that violates freedom of speech to say, to who the owner could be. Based on very brief news reports I looked at, it sounded like the court might not have been that sympathetic to that argument, although, it can be dangerous to predict what the court is going to do based on oral argument.
Sure.
But again, with the major caveat that I haven't dug into that's on my to-do list of things to dig into. If I'm right that it was primarily a First Amendment challenge, that is a different kind of challenge than a major questions challenge. Now, of course, you could bring both, and it's quite possible that that TikTok in that case challenged the government's action both on First Amendment grounds, in other words, the constitutional ground that it impinges on our freedom of speech, and on administrative law grounds such as that an agency was doing something of major economic and political significance, and therefore Congress needs to do it, the agency can't do it. But again, maybe we should talk after I've listened to that argument.
Yeah, sure, of course. Yeah, so tell us some other ways, whether connected or disconnected from the Chevron doctrine, that that things are in place that are going to weaken the administrative state?
Oh, so there were, in addition to the major questions doctrine that Josh mentioned, there were four other big decisions this past term that, all of which I think aggrandized the courts and limited administrative agencies. One was a decision called Corner Post, which involved the statute of limit. It sounds really technical and boring, and to some extent it is, but it was about the statute of limitations for challenging an agency action. And the court reinterpreted the statute of limitations in the Administrative Procedure Act to say that statute of limitations, so statute of limitations, for listeners who don't know, is basically a law that says how long you have to bring a legal challenge in court when you get injured. So, if somebody hits you while they're driving under state tort law, there would be a fixed amount of time. And, in some states it would be 1 year or 2 years, 3 years, whatever it is. But after that amount of time, after those years have passed, the statute of limitations has run out and you can no longer bring that lawsuit, even though you could have at the time it happened. So the Administrative Procedure Act has statute of limitations, and the court reinterpreted that in Corner Post to say that it starts running whenever an agency action applies for the first time to an entity. So what that effectively means is you could have a brand new business that was incorporated, yesterday, so the administrative agency action that could have been 30 years ago didn't start applying to that new business till yesterday because the business didn't exist till yesterday. Well, they could still file a lawsuit challenging that administrative action. So, that's a relatively big deal because agency actions that happened 10, 20, 30 years ago that were thought to be, sort of stable and fixed law because the statute of limitations was thought to have run a long time ago, now could be challenged again by new businesses. So that lends more uncertainty to this to this area.
Yeah, well, just real fast. So, like with the statute of limitation, expiring and all that stuff, and then folks can bring legal challenges. I mean, like as you're talking, I'm just thinking like document retention. Like I'd imagine a lot of these companies are like, oh yeah, we only have to hold on to them for 5 years, So and then afterwards we'll go and shred everything.
Well, I think that's a good point. I think, I guess in the instance of a brand new company, I guess they don't need to worry about that. But, the larger point I'll make is a lot of this is actually quite, and then this was sort of going to be a bigger picture takeaway, is that this actually can be quite destabilizing, not just for government, but for industry as well. I think all these changes we're talking about to the administrative state and to regulation more generally is sort of unsettling the playing field. And a lot of businesses don't know exactly what the rules are. I think there's no question that there are some regulations that are too expensive. And there's certainly businesses that want to get out from under burdensome and very costly regulations. But businesses also do prize predictability because that allows them to plan. And I do think that one of the results of the many changes in administrative law the court has made over the last couple of years is that the state of regulatory law in this country is now quite uncertain, which means that businesses don't know exactly what the law is. And there's some anxiety about this. I actually happened to be at a conference last summer talking to sort of leaders from a bunch of different areas, mostly non-lawyers. And I was asked to summarize some of these changes to some business leaders, and they were really stressed out about it, especially the smaller, like the small tech startups, who don't have, not a massive corporation that has a massive counsel, lawyers, a huge group of lawyers they can set to figure this out. But, small tech startups that are very leanly run, that they set up under one set of rules, and now all of a sudden there's a whole different set of rules. It really produced a lot of anxiety for them. So I think that's a good point. And I guess quickly, if it's okay, I'll just really quickly just run through some of those other decisions.
Yeah.
So that was a corner post about statute of limitations. Another one was a case called Jarkissi, which involved enforcement proceedings. The SEC, Securities and Exchange Commission, conducts enforcement proceedings where it can apply its rules in internal agency proceedings against, companies that violate securities laws. And the court signaled that a lot of those kinds of disputes have to happen in federal court rather than in the agency's internal adjudications. There's a good number of agencies that handle at least their initial enforcement proceedings in internal adjudications within the agency. Those are appealable to federal courts, but they usually begin in the agency because it's a lot more efficient for the agency. So by signaling that at least some of these will have to be in federal court from the beginning, that's going to make it harder for agencies to enforce their own rules, which means rules that are designed, in the case of securities laws, to keep Americans, investors safe from fraud in the financial markets. Those are going to be harder to enforce for agencies. And then the very final decision I'll just very briefly mention, which I don't want to get into because it's highly technical, but there's a case called Ohio v. EPA, and that was basically a case where EPA had done something. They'd given a pretty detailed explanation, and the court said, "No, your explanation isn't good enough. You need to give, it wasn't a thorough and reasonable enough explanation. You need to give more details. You need to answer this. You need to answer that." And in that case, even Justice Barrett, who's a conservative justice appointed by Justice Trump, she actually wrote the dissent because I think she just thought the majority opinion was pretty poorly reasoned. But again, it signals that I think it gives a sense of how willing the Supreme Court is to second guess what agencies are doing. To say like, oh, well, you gave an explanation, it wasn't good enough, it wasn't thorough enough. So I think, in conjunction with all those other decisions I summarized, it just signals that the federal courts are really holding agencies' feet to the fire and second guessing them a lot.
So, I guess I have. I guess there's so many questions I have in my mind, right? We have our interview questions that we've written and that are then spurring on other questions, and the conversation is spurring on other questions in my mind. And I guess, if I'm thinking about there's kind of two aspects of this. We're going to have in this next Trump term, it seems like to me, we're going to have, maybe more than normal. I don't know. I'm not even sure how to really judge that, but there's going to be some significant decisions, it seems like, that are going to be made. Things are going to go to the courts. They're going to be, I'm not sure if he's going to have an opportunity to appoint another judge, which is, obviously likely, or certainly potentially could happen, and maybe very likely will happen, right? That he'll have an opportunity to appoint another judge. Maybe even two. I mean, last time he got three, or how many did he get? 3 or 4? I don't remember. 3, which is a big deal, right? So he's going to have a lot of, again, power of reshaping, and along with his allies, reshaping our court systems. And I would just love for you to address, because kind of my question is, how concerned should we be? But if I'm getting really, like the normal person, how concerned should they be with all of this? But if I'm getting even deeper, it's almost like a procedural question of so you mentioned oral arguments, and you mentioned like they bring these arguments, they bring them to the Supreme Court. Like, is there any difference that these things make, or have the justices, whether it's state Supreme Court, whether it's federal circuit courts, whether it's the Supreme Court of Appeals, have they already like almost made their decisions before these things are even brought? Like, is it that people are trying to strategically, I mean, I know that there's strategy in this, like, hey, we need to get this court get this in there. We need to violate this law or make this law or do whatever it is so that we can then push it, get this hopefully up to the Supreme Court. I don't know who makes those decisions. I don't know how that works. If there is like someone that can be a mastermind behind trying to figure out how we get certain appeals or certain cases to the court in order to shape because they are predicting the court will go in a certain way. Like, I guess maybe even deeper. And I know that, but it's like, how fair is it right now? Do you think that actually both sides are being heard, good legal decisions are being made, and the normal person can rest easy and say, yes, I trust my Supreme Court to act in my best interest? I know that's a big question. I answer it however you feel.
So, very briefly, to just address one of the first things you said, President Trump will certainly have the opportunity to appoint many lower federal court judges to the federal trial courts and the intermediate federal appellate courts. And in some ways, that's hugely important because those are the judges that hear the vast majority of cases. The Supreme Court obviously hears the biggest ticket cases, maybe the most newsworthy cases. But the most of the work the federal judiciary does are in those lower courts. So those judges can make a big difference. And for instance, in the Florida documents case that was filed against President Trump, I think a lot of observers thought that the judge in that case was pretty biased in favor of the president. Now, I think a lot of probably most federal judges were both conservative and liberal, served with great distinction, and try hard to not let their own political biases filter into their legal decisions. But I don't think it's an accident. I don't think it's an overstatement to say that President Trump has a transactional view of politics. So it is certainly conceivable that he would appoint people to the federal judiciary who he thought would, do his bidding or help him advance his agenda. And, there might be people he appoints thinking they'll do that, and they won't do that because they'll be independent. And historically, our courts have been pretty good at being independent. But that's always a risk. At the Supreme Court, it's hard to know whether he'll get any appointments. I know some conservatives are clamoring for Justice Thomas and Justice Alito, both of whom are in their 70s, to retire, so that President Trump can replace them with, like 20-year-olds or something who will be on the court for the next 100 years.
No, I believe Eileen Cannon is 37, if I remember right.
Yeah, so right.
Dang.
In terms of, how kind of fair I think the court is, obviously that's a huge question. I think the losing side in litigation, has always said that the court was unfair. One of the classes I teach in my law school is constitutional history, and one of the issues we dig into there is slavery, because that's, for obvious reasons, not an issue you really dig into in an ordinary constitutional law class because it's not relevant really to the practicing lawyer. But it really gives a sense of how constitutional issues, the most hot button and explosive constitutional issues of that era, played out. And certainly in those days, people on the losing sides of those issues thought that the court was partisan. So to some extent, there's always that charge. I do think the current Supreme Court is a little bit different in worrisome ways. I think several of the justices on that court, it appears they have made up their mind in a case before arguments, before briefs, and that is not the way that I think federal judges should be making decisions. So that's worrisome. I think another thing that at least looks bad is we've become so partisan that on a lot of really big issues, it's very easy to predict which justices on the Supreme Court will vote the way they will based on the party of the president who appointed them. And that didn't used to be the case. We used to have conservative justices and more liberal justices, but that was less predictable based on who had appointed them. And in fact, there were some, relatively progressive justices, Justice Stevens, Justice Souter, for instance, who had been appointed by Republican appointees. But the whole nominations and confirmation process has become so politicized and is so sort of tightly reviewed by the president's handlers that that you end up with a lot of cases where there's a 6-3 split along party lines. And I think that's really bad for perception, and that's bad for the rule of law. Obviously there are cases that, can cut against that thesis. I don't always agree with her, but I've actually been quite impressed with Justice Barrett's independence. I think, again, I don't always agree with her. There's some cases I really disagree with her, but I think she has proven herself to be a thoughtful and independent-minded justice so far, who will call it as she sees it and will not just mark and lockstep with the preferences of the party that appointed her. So I think that is encouraging, and I think there are many, many lower federal court judges, appointees by both parties who, like Justice Barrett, show a fair amount of independence. But I think it is, I think the question you raise is troubling, and I guess the biggest point I'll make is what I'm most worried about are threats to democracy or cases involving democracy. And this is sort of getting us a little bit further afield from the administrative state issues, which we can return to. But it is no surprise. I can understand the progressives are upset, but they should not be surprised that a Supreme Court dominated by Republican appointees would overturn Roe v. Wade. That has been a goal of the conservative legal movement for decades. And, again, progressives are going to be angry about that, and I can understand that. But if you had asked, many of us when I was in law school, if the Republicans got a 6-3 majority, or would they overturn Roe v. Wade? I think most of us thought they were trying to do that. And if anything, the surprise was it took as long as it did. There are other cases, though, involving, for instance, the gutting of the Voting Rights Act, the green lighting of partisan gerrymandering, and saying, we courts can't do anything about partisan gerrymandering. And frankly, the broad criminal immunity extended to a former president who, was accused of trying to overturn the results of a democratic election. Those decisions, I think, are in my mind far more troubling, because that's not just a sort of culture war kind of issue where liberals and conservatives are just going to disagree about how to see it. Those kinds of cases more implicate the very structures of our democracy, the right to vote, the way district lines are drawn, and whether they can be drawn in such partisan ways as to highly favor the party in power, whether we can insulate a political figure who who allegedly tried to overturn the results of an election from criminal prosecution. I think those are the cases that trouble me most. And, those are the cases where the sorts of charges that you raise, Josh, I think are sort of loudest and the ones that we should all pay attention to the most.
Oh, wow. So this would be my my last question, our last question. Just to kind of, tie a nice bow on it, as far as should a bunch of Schedule F employees get nixed, civil service folks, get fired because they're not loyal enough, um, or just the general degradation of the administrative state. What are some signs you think? And it's kind of broad, so I give you like broad, latitude to kind of just pick an agency and then go with it. But what would be some signs that these agencies are not performing or doing what they're supposed to be doing, and then how does that gap get filled?
I think to some extent, any time you have a change of the party that controls the White House, you're going to have a pretty significant change in policy at at a lot of agencies that do work in areas with high political salience. So there is a bit of whiplash where the EPA under a Democratic administration is going to be worried about the environment and climate change, and under a Republican administration is going to be more concerned about protecting businesses from overregulation. So, to some extent, I think those kinds of policy shifts are inevitable, especially given how deeply partisan and divided our country is. And sort of parenthetically, though I myself am largely a believer in and defender of the administrative state, that is a critique of the current structure of our administrative state that I think is fair. In other words, that the fact that the law can change depending on who's in the White House and can change pretty dramatically, I think that's a serious problem. And I think that's one of the issues that is driving the Supreme Court in these cases. I guess my own view is that I think the court got many of those cases wrong as a legal matter, but I think that is a non-frivolous concern about the administrative state. And I guess I say that in part because there will be policies that progressives in particular are worried about over the coming years. Certainly policies involving the environment and climate change in particular. We'll see whether Robert Kennedy gets through as head of Agent Human Services, but there could be vaccine skepticism could filter down in that agency, things like that. And I don't mean to minimize the importance of those particular policies because those policies matter. If you believe climate scientists that we are at an almost existential tipping point with threats to climate change, then 4 years of non-climate friendly policies, or I said that badly, policies that are not friendly to the climate, could be in the nation's wealthiest or the world's wealthiest nation could be, very bad for the long-term environmental prospects of the planet. So I don't want to minimize that, but in a way, I think we ought to be most worried about are more changes to the whole structure of the administrative state, where the President Trump, at least allegedly, is trying to mold the whole structure of the government to do his bidding. In other words, where those kinds of structural changes could outlast this presidency and move into the future. And one point I'll make is, in some autocratic regimes like Viktor Orban's Hungary, one of the moves that President Orban in Hungary and other autocrats have done this in other countries as well has been to bring the civil service, what we call the administrate, more fully under the control of the president, so that the head of state can basically get government to work for him rather than the people at large. There's actually coincidentally a very good op-ed on this topic by Kim Schlepley and Norm Eisen in the New York Times today about, are we sleepwalking into an autocracy? And, to be clear, I'm not at all certain that we are sleepwalking into autocracy, but I think it is a non-frivolous concern. I think it is something that Americans of all political persuasions really need to have their eyes open to. And again, I guess I would urge Americans to try to see the difference between, sort of ordinary policy disputes where conservatives and liberals are just going to disagree about what the best policy is, and attempts to reshape government in ways to bring it all under the thumb of one person, which in other countries has been catastrophic for the health of democracy.
Yeah, I don't know about sleepwalking towards autocracy, but I do know if you are sleepwalking towards autocracy, you'll end up tripping on oligarchy with Elon Musk probably going to get like a seat in the Oval Office, I'm sure. Like, but well, Eric, thank you so much.
If you don't mind, if I could just make.
Oh yeah. Go ahead.
Please. I mean, I could keep listening to this, man. It's like, this is like on my mind. It's on our mind all the time, this stuff.
I'm sorry, I'm sorry to ramble so much, but, to the point you just made, Will, I think one thing that is also a little concerning is how many big businesses we have seen in recent weeks who have changed their tune on various issues to appease President-elect Trump. The most recent prominent example is Mark Zuckerberg of Meta saying, well, we're not going to do fact checking anymore. And that was in part because of, or in large part because of pressure from President Trump and his allies. I mean, I think that implicates a much larger issue of facts in this country, and how there's so much misinformation and disinformation out there, and it's very, very hard for a lot of Americans to sort between what are legitimate facts and what are not. But I raise it in this context because I think it's relevant to the point you made, Will, about oligarchy. That if we're letting big businesses call the shots, and if big businesses are, rather than doing what they had said earlier that they thought was right, but are now bowing to the wishes of the president-elect, that can be another, dangerous step towards autocracy. And again, I'm not saying we're there. I don't think we are there, but I do think we have to be careful and watch very carefully what happens.
Yeah, well, Eric, thank you so much for speaking with us.
Yes,
this has been really, really enlightening. And one of these days when we have you on, I want to ask you about homework that you've given your students, so that way you can recognize which of your students listens all the way to the end of our podcast. So it's like, you put a question on the board, and at the very end, you tell your students, hey, tomorrow morning, I want you to have an answer for this, but then you tell us the answer. I mean, there'll be a lot of coordinating, but I do think it'd be kind of fun. So, that said, yeah, go ahead.
Thank you again for having me. I think I said this one of the other times I was on your show, but I think you are doing a great service to the country. I think one of the things I really worry about in this country is we have lost the ability to respectfully disagree with each other, and liberals and conservatives have lost the ability to talk to each other, and that is extremely damaging. And rather than realizing that we're friends and relatives and fellow patriots, all too often we see each other as the enemies. So to bring liberals and conservatives and people of faith together on your show, I think is an incredible service. So thank you for the work you're doing, and thank you for having me back.
Yeah. Thank you so much. And to our listeners and watchers, thanks for joining us again for another episode of Faithful Politics. Again, make sure you like and subscribe. It definitely helps us quite a bit. And as always, keep your conversations not right or left, but up. And we'll see you next time. Take care. See ya. Yeah, thanks again.